Well, joining us for more legal analysis is Melusi Xulu, Managing Director at Donda Attorneys. Melusi, a very good afternoon to you. Thanks very much for your time. Let's start where the spokesperson of the NPA left off, which is that the fact that she had to be extradited, gives a strong opinion, like there's a strong likelihood that she may disappear.
Good afternoon to you and to the viewers at home. I think what the spokesperson is raising is one of the crucial issues which the state will raise in opposing bail, because remember, whenever we're doing bail, the issue is, will you be a person trusted enough when you are given bail to not be a flight risk? So I think what the accused has to do is to prove that she's not a flight risk, but the fact that an extradition had to be done might be a bit of an issue against her. But the test is, when she was needed to come to South Africa, I think she was requested to come and testify, and she refused to come as a witness. What I don't know is, when they told her they needed to come back so that she can be arrested, did they communicate that to her? And if they did so, then it might be an issue if she refused when she was requested to come to South Africa as an accused. I think the two are different.
I think that's, my pedestrian understanding of those things. But going into today's court appearance, her lawyers seemed very confident that there would be no reason for the court to deny her bail.
Yeah, whenever we're doing bail, we need to find out, will you interfere with the state witnesses? Will you interfere with the evidence? Will you be a flight risk? Will you also not commit what we call a Schedule 1 offense? We also look at the background as well. Have you committed crimes before? Have you been convicted? And have you been in flight risk before? And what is crucial is, even if there are certain things that look like they are an issue when it comes to you getting bail, conditions can be set. Simply to say you should not leave Bloemfontein. If you're going to leave Bloemfontein, you must request the IO, or you must tell the IO that you need to go to Johannesburg. And most importantly, your passport, it must be with the investigating officer, the IO. So I think those are the things that might be discussed when it comes to conditions. Because at the end of the day, I always like to refer to this state case of S versus Eckerson in 1991 case. It's a Namibian case, but we use it in our case laws in South Africa. It says that a bail is not necessarily an opportunity to punish the accused before the trial has been done. I'm just paraphrasing. So in essence, she's still deemed to be innocent until proven guilty. And the only thing that matters here is, if she's given bail, can she be trusted to respect the bail conditions that she'll be given? That is the test.
Would that be the only test? I'm asking this on the back of how events unfolded. Remember, she was the person to spill the beans. She was the person to agree to cooperate with the state, only to make an about 10. How much of that, or how those events unfolded, could work against her application?
Yeah, in the first instance, she was supposed to be a witness, and then obviously the issue that the state has with her is that she did not, cooperate with them. But what has happened then is that they further then charged her with the cases of corruption, money laundering, and fraud, and so forth. So I think it does not work in her favor that she looks like she was a witness who did not want to work with the state. That is noted. But here she's charged with fraud, corruption, and money laundering. So now we are looking at her as an accused, not as a witness who's refusing to assist the state. We're looking at her as a witness, and her rights as well as an accused will have to be looked at from a constitutional perspective. So I think what matters more than anything is to look at her rights for bail application, and whether, if she's not given bail, maybe the fact that she might be a flight risk, is that enough? Do they have a case for that she's a flight risk? Remember, we've tested this kind of issue in another high-profile case of Nandipa, where they escaped to Tanzania, away from, I mean, she was with Thabo Bester for a year, then they escaped to Tanzania. That's a little bit different. Here she went to USA, and she did not want to come back to come as a witness for the state. But my question is, if the states can prove that they told her to come to South Africa, back to South Africa as an accused, maybe that is different to show that she was now running away. So they even had to go to Maryland courts, if you can check the reports, where the judge was of the view that she must be extradited for a serious offenses of such nature. So I think what is important is, does she qualify as a person for bail? I think that will depend on how they look at the issues of the fact that she had to be extradited back to South Africa.
Yeah, she tried everything, I mean, to stop the extradition, even trying to petition the Constitutional Court. But going back to what Judge Aaron Aslan of the Maryland District Court had to say before granting the extradition request, and I'm going to quote some said, the request was accompanied by indictments, sworn statements and affidavits, a forensic audit, emails and many other documents, all of which amply support a finding of probable cause to believe that both Cholota in the individual, as the individual named in the pending court South African indictment, and that she committed the charged offenses. How much should we read into that? And I'm asking this on the back of criticism. I mean, I was looking at social media this morning. A lot of people saying, well, hopefully the NPA does have a case. And people are saying that on the back of many of these such cases collapsing at when it comes to the courts. How much should I read into what Judge Aslan had to say upon agreeing to the extradition request?
Well, it looks like maybe prima facie when she was or he was looking at the application for extradition, it looked like there is a case to answer for the accused when she was brought back, and for her to say that extradition should be allowed. But I think that is we need to separate the two. There's an application for an extradition for her to come back to South Africa so that she can be dealt with in our criminal justice system. Now, the second part, which is indirectly linked obviously to the extradition, is that she qualified then for a bail application. Because whenever we're doing bail, we don't necessarily look at the merits of the case, but we focus on the fact that does this person, in terms of the likelihoods that are in Section 6, Subsection 4 of the Criminal Procedure Act, make it to qualify. But most importantly, we also look at Section 35, Subsection 1, Paragraph F of the Constitution that says every arrested person has the right to be released if the interest of justice permits. So that is the standard that we're looking at from a constitutional perspective, bearing in mind of the facts, bearing in mind that there might be a strong case, but we have to look at the fact that she has a constitutional right to be released if the interest of justice permit. So it will be a very interesting angle to look at that. Does she qualify for bail when an extradition had to be applied for? And we'll have to then to look at why was the extradition done? Was she refusing to come back to South Africa? But can the state prove that this is a person that will run away? And possibly, if that is proved, she might not get bail. But as I've said, the state needs to be able to prove that, they requested her to come to South Africa before the extradition application was done, and she refused. And obviously, she might have been refusing in Maryland court to come back to South Africa. Hence, an extradition was done. So all I'm saying is, we must not focus so much on the merits of the case, but we must focus on the likelihoods that are in the Criminal Procedure Act that she might interfere with state witnesses, that she might be a flight risk, and the criminal justice system might be affected by her release. So I think tomorrow more will be dealt with with regards to heads of argument, and then the judgment will be given possibly tomorrow or in the next coming days.
And that's where the focus should be on, not for the time being, certainly, what her family believes is the wrong way of going about this whole case. That a lot of time and resources is being spent going for the sardines when they believe that the state should be going for the big fish. But that's why we're going to leave.